Everyone, this is Wafaya, and I'm gonna introduce to you today the usufruct. So, the most important question: what is the usufruct, also known as niche Kauf in German law? It was incorporated through the Civil Code, the BGB, which was enticed and introduced in the 1900s. The roots of the German usufruct law was traced back to the Roman law. It includes two parties: the person entitled to be the usufructuary and the owner, which can be also called as the bear owner. A usufruct is an in rem right. Usufruct is the right to use a specific property and take income from it, despite not being the property owner. It enables one individual to gain the economic benefit from an asset while another retains legal ownership. As a usufructuary, you have the right to use the house, apartment, or land and earn the income from it, such as rent, without being registered as the owner in the land registration. Key aspects of the German usufruct is for the right to use and income, separation of ownership, maintenance obligation, and restrictions. Creation of the usufruct is by three ways: either by agreement, also known as the contract, by inheritance through a will, or another way or other ways like perceptions. Uh, Termination of the usufruct is also one of two things: either for a lifetime of the usufructuary or a limited time period. The rights and obligations between the usufructuary and the bear owner. The usufructuary bears the current public charges like property tax and street cleaning and waste collection, the current private charges, and the maintenance of the property and the income taxes, since he's the one who benefits from the property. The bear owner bears the public charges that concern the original value of the real estate property and repayments on mortgages and land charges. So there are three forms of the usufruct. The first one, the owner transfers the usufructuary right to another person. For example, when an owner decides that his son may dispose of the rental income, or two, the reserved usufruct, which is the most known, when the owner gives the house as a gift, retains the right to live in the property. For example, if a parent donates the property to their children during their lifetime. Or the third case of the subordinate usufruct, when a third person is specified to whom the usufruct passes after the death of the current usufructuary, for example, the children or the partner. So the most common use is the reserved usufruct. So we can have an example for that, or we can focus on that. For example, if Mr. Muller owns a three-story apartment in Munich, valued at 1.2 million, he wants to ensure that his wife Maria is financially secure after his death, but he also wants the property to stay in the family. So he's gonna give it to his daughter Anne by, for example, a will, stating that he wants to give the resident building in Munich to his daughter Anna Muller, subject to a lifetime long usufruct in the favor of his wife, Mrs. Maria Muller. So the legal consequences is going to be the ownership split when Anna becomes the bear owner and Maria becomes the usufructuary. So keeping the right of the usufructuary, Mrs. Maria, she can live in the apartment or the property herself or rent it out. She has the right to collect the rental income. She must maintain the property and she cannot sell the property because she's not the owner. Obligations that Maria must pay property maintenance, and Anna has to pay the larger structure repairs, like, for example, repairing the roof. In the end of the usufructuary, it's going to happen when Maria dies, for example, the usufructuary automatically ends and Anna then becomes the full owner, gaining the right to use and rent or sell the building. So I hope you now know what is the usufruct and you understand it more by the example. Thank you so much. Have a nice day.